Leveraging Inspiration, the Inspired Patent Podcast, where we explore the world of innovation, creativity, and intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from inventors, entrepreneurs, and experts in the field. Today, we're talking about the question of, can you use a competitor's trademark term as a keyword in advertising, an ad word? On the first episode, I talked about trademark law, how it works. Courts consider the question, are consumers likely to be confused in the specific situation? So here's one specific situation. It was a US case of Merck versus Mediplan Health Consulting and others. Actually, there's a bunch of companies they were suing. Merck is a drug company. They have a bunch of different drugs. One of them is Zocor, Zocor. And there were several Canadian companies using the trademark name Zocor as a keyword, and they were selling competing medications. They were targeting US consumers and primarily selling to US consumers. So their advertisements showed the term generic Zocor, those two words together, the word generic and then the trademark term Zocor. And those links went to competing products. The medication is for blood pressure. Those Canadian companies were also selling Zocor that was manufactured by a Canadian manufacturer that was authorized by Merck, the owner of the Zocor brand. And so they had permission to sell Zocor and were selling Zocor, but we're also selling a generic version of the drug. The drug is called simvastatin. The Canadian companies were trying to get the trademark part of the lawsuit thrown out, and that part was on appeal. The law allows the court to rule that a plaintiff's claim, which is a trademark infringement claim in this one, could not even succeed, even if everything that was said in the initial complaint was proven to be true. The court had a few different issues. The first one was trademark infringement based on the use of Zocor on their websites. The second one was trademark infringement based on the purchase of sponsored links from the internet or through search companies. And when people were typing in Zocor with the links to these Canadian companies' pharmacies' websites. And one of the things they said in this case, another way to explain trademark infringement is trademark infringement requires a showing that an appreciable number of ordinary prudent purchasers are likely to be misled or indeed simply confused as to the source of the goods in question. So in other words, if they think they are buying from Merck or something that's authorized from Merck when they are not, then that is trademark confusion. One of the things that the court in this Merck case said is that trademark infringement is very fact specific, and everything in the complaint is considered as proven for the motion. So this stage of the case, they're asking, on these facts, if they were all proven as true, is this trademark infringement, or is this clearly not trademark infringement as a matter of law? There were multiple companies, and one of the companies was not using the term generic Zocor. And that term, generic Zocor, may sound like it's pretty clear. This is a generic version of the drug Zocor. The court said it's just not clear enough. There's enough ambiguity that we need to have more information, more facts, more discovery to determine, is the term generic Zocor going to confuse people into thinking this is a Zocor, but it's a generic version, and it is the trademarked product by Merck, but it's a generic version. So the judge said he could not say as a matter of law that the term generic Zocor was not going to confuse people. I can understand marketing people, they want to use as few words as possible, but here, because they brought it all the way down to generic Zocor, the case against the companies using the term generic Zocor was allowed to go forward. And the one company that did not use generic Zocor, They only said generic simvastatin, and they sold the generic product next to the Merck product. So on the web page, it was clear, if you buy this one, this is Zocor. If you buy this one, it's generic simvastatin. Since they didn't use the word generic Zocor, the court said they did nothing on their website different than retail stores that place the generic product next to the brand product, which is not trademark infringement. In those specific circumstances, they said that's not trademark infringement. Then the court addressed whether there was trademark infringement through keywords. Lawsuits have multiple claims. One of the claims was the infringement of use on their websites, and another one was using the keyword Zocor to direct people on an ad to the website. The court said, defendants argue that this claim should be dismissed as a matter of law because purchasing Zocor as a keyword on the internet search engines does not constitute trademark use. And the judge in this case said, I agree with defendants. Now, this really made things confusing, and another court cleared this up. But there are some technical parts of trademark law where you have to show that you use the trademark in order to obtain the registration. Trademark statutes, they're discussing both trademark registration and trademark infringement at the same time. So this is something that Congress really needs to clarify and separate those two and say, this is the standard when it's trademark registration. And when we're talking about trademark infringement, this is the standard. So it got muddled. And the question of trademark use is, are you infringing if you're using the trademark, or if you're not using the trademark to the standard of being able to file a trademark? In other words, did you affix or associate the brand directly with the product? If it's indirect, the trademark office, when you apply for a trademark, will say that's not trademark use. So if you have an ad, a keyword ad, and in the text of the ad, it says the brand, you click on it, there's nothing on the web page that says that brand, but there's an opportunity to purchase. Trademark office will deny your registration, saying you have not proved that you accomplished trademark use. So the argument was, because the statute says you have to use the trademark in order for it to be infringing, there's a section that discussed both of them. So it got muddled. And the court didn't need to actually say that statement. And so in the search engine context, defendants in this case did not place Zocor marks on any goods or containers or displays or documents that associate them, nor did they use them in any way to indicate a source or sponsorship. Rather, the Zocor mark is, quote, used only in the sense that a computer's user's search of the keyword Zocor will trigger the display of sponsored links to defendants' websites. So they said it's an internal use of the mark Zocor as a keyword. Now, that internal use actually that language came from a different case where it truly was internal. The people purchasing keywords through a system that they didn't get to say, if this keyword shows up, show my ad. It was much more like the yellow pages. When you wanted to put an ad in the yellow pages, you said, this is the category. That's the section I want to be in. So there was an advertisement service where they said, okay, this is the category you're in. And in that category, when they determine somebody is looking for something in that category, they put in trademark terms. And then they would deliver one of the listings in their yellow pages. In that case, it was truly an internal trigger. And it wasn't necessarily the case in this one, but that language started its way into other cases. And so at the end of the day, the keyword claim was dismissed, at least in part, because the Canadian pharmacy website sold authorized Zocor. They were allowed to advertise and put in the keyword Zocor because they had Zocor authorized products on their website. So the court didn't need to go into this question of, is it use? Because at the end of the day, they had permission for selling the authorized product. If I bought a whole bunch of one brand's product and I was selling that brand's product, I'm allowed to use their trademark and to tell people that's what I'm selling. That was the case here. Another case I'm going to go through real quick is Lone Street. Lone Street is a company that fired an employee, but 2 months before this employee was fired, his name is Wyatt, he started posting disparaging statements about Lone Street and one of their executives and other Lone Street employees on various websites across the internet. So he went on Glassdoor.com, Reddit.com, TeamBlind.com, and his beef with them was that he believed he was entitled to over $100,000 worth of stock options. And so the court, they summarized what happened here. They said on the day of Wyatt's firing, he sent a company-wide message via Slack, followed by an identical email sent to the company owner with the entire company copied, calling the company and its leadership into disrepute and saying that he would, quote, be doing his best to warn all potential future employees to avoid Lone Street. So Wyatt was so upset that he purchased keyword ads so that when people searched for Lone Street, they would be directed to Wyatt's posts on Reddit and other sites. This purchase of keywords is very likely trademark infringement. And this was a case where, like the previous one I was just talking about, it was at a motion to dismiss stage. And the court said that Lone Street's, so Wyatt was trying to get this dismissed, saying, I can purchase keywords. That's not infringement. Some of Lone Street's other claims were knocked out, but enough remained to proceed with the lawsuit. According to the court, Wyatt was not entitled to the stock options. And instead of getting stock options worth $100,000, he may have spent $100,000 defending the lawsuit. So I do not recommend this method of dealing with being fired. And I expect what he did and the public nature of his posts and this court case will make it very hard for Wyatt to ever find a position similar to the one he had at Lone Street. That's all the time we have for this episode, but we'll be back and we've got more examples of